Hey everyone, I'm attorney Bianca Jordan from Brazen Legal. Thanks for tuning into this video. If you haven't already, please be sure to subscribe to the channel and follow me at Brazen Lawyer on Instagram so you don't miss any of my immigration news videos and tips that I share to make your immigration applications a little bit better. Today's video is about USCIS's announcement last week that it would be increasing discretion in some of its immigration cases, including green card cases and applications for work cards. So to be clear, there has always been a level of discretion in a lot of immigration cases. For example, if you're applying for adjustment of status, which means that you're applying to get your green card within the United States without going back to your home country, the law says that immigration can adjust your status to give you a green card at their discretion. So the concept of discretion in immigration cases is not new. But over the summer, back in July 2020, USCIS published a policy alert that said that it would be increasing discretion for certain cases and it would be updating its policy manual to add a new chapter on their discretionary analysis, and that they would be applying this discretionary analysis to cases such as work card applications that are filed during green card applications that are pending. So typically, the work card was pretty much a given in those situations. So for example, if you are an immigrant in the United States and you are applying for a green card because you are married to a US citizen spouse, those applications, you would typically also file a work card application and you would get your work card so that you're able to work in the United States lawfully while that green card application is pending. But now we've got this new discretionary analysis process that's going to be applied to applications such as this. So, what's happening? Why is this happening? And what does that mean for your immigration case? So it's no secret by now that the Trump administration has, from day one, wanted to make immigration harder for immigrants. It wanted to make the process more difficult, more costly for immigrants to be able to get green cards and work cards in the United States. This new policy change is pretty much in line with that goal. So this is just an attempt again to throw another wrench in the immigration system, especially before Trump leaves office, to try to make the process a little bit more difficult for immigrants. So under this new process, immigration officers are going to have to go through this discretionary analysis before they can approve somebody's application. So first, the immigration officer is going to look at all of the facts of your case. They could go back as far as the beginning of time to see if you've ever applied for a visitor's visa, and they can look at that application to see if there are any inconsistencies between what you put on your visitor's visa application versus what you're putting on your green card application. For example, I've seen situations where people's green card applications are denied for fraud or misrepresentation because maybe on the visitor's visa they said that they were married with children back in France, and then now on the green card application they're saying they never got married. Or maybe when they were applying for an I-130, they didn't mention that they have 4 children because maybe they were afraid of not being able to meet the affidavit of support income requirement, and then now years later they're trying to petition for children that existed at the time of the I-130 but that weren't mentioned. So they can look at anything in your immigration history. They can go back in time to see what you put on that visitor's visa application. Or one thing that I've been seeing more often is that immigration officers are going back to see if people had ever applied for asylum, and they're going through to look to see what you put on that asylum application to see if they can use that against you now to deny your green card application that you're filing in 2020. So they're going to look at all of the facts of your case, go through your entire immigration history to not only see if you meet the legal requirements of the law, but also to see if they can find anything in your file that would give them a cause to deny your application. So when I say the legal requirements, for example, if you are trying to apply for a green card because you're married to a United States citizen and you're in the United States right now, you have to, they're going to look to make sure that you came to the United States legally. They're going to look to make sure that you're an immediate relative. So in other words, they want to make sure that the person that is petitioning for you to get that green card is a US citizen. They're also going to make sure that you're admissible to the United States. And admissible just means that there isn't a reason that the United States could deny you a visa or a waiver. And there's a long list of things that could possibly make you inadmissible to the United States, such as, if you're a public charge, if you came here undocumented, if you have certain medical diseases, if you've ever been deported, if you're a terrorist. There's a whole long list of things that the government can use against you to keep you from getting a green card or a work card or a visa or what have you. So they're going to look through your entire history, the facts of your case, to determine, do you meet the legal requirements? Is there anything that they can use to say that you don't? And if they come to the conclusion that you do qualify for the immigration benefit that you're applying for, they're next going to go to, does your application deserve to be approved as a matter of discretion? And would approving your application be in the best interest of the United States, whatever that is supposed to mean? So when they're going through this analysis, it's basically a very in-depth pros and con analysis for your case. Like I said, they're going to look through your entire immigration history, which they can already do as well, but as part of this analysis, they're going to have to do that. And they're also going to look at things like, how long have you been in the United States? Have you ever violated any immigration laws? For example, have you ever come to the U.S. undocumented? Have you ever tried to smuggle people into the United States? Have you ever violated an immigration policy? For example, have you come to the United States with a visitor's visa and overstayed your visa? Or have you come to the United States with a visitor's visa and then gone and gotten a job? They're going to look to see what your family and community ties are in the United States. They just really want to do a really thorough pro-con analysis to determine if you're worthy of having them approve your application. So some of the applications that will be subject to this discretionary analysis are applications for temporary protected status, so TPS, applications for a work card, applications for adjustment of status, asylum, immigration waivers, applications to change or extend your status. For example, if you wanted to extend a visa. This is just a short list. There's a longer list, but these are really just the ones that I mostly focus on, or the ones that I see the most in my practice. So what does this all boil down to for your case? Even if the law says that you qualify for this immigration benefit, the law says you qualify for asylum or a green card or the work card, you're basically going to have to prove to immigration that you're worthy of having them approve your application and that it's in the best interest of this country to do so. So you're really going to have to work hard to go above and beyond and make sure that your case paints the best picture of your immigration story. And this also means that if you've ever had anything negative, for example, the work hard analysis might be very problematic for a lot of immigrants, especially, for example, people that have DACA. A lot of people that have DACA came to the United States undocumented through no fault of their own. A lot of them were brought over to the United States by their parents, so they didn't know they were coming here undocumented. But now they want to apply for a work card through DACA. Under this analysis, immigration would treat that as a negative because you entered the United States undocumented. So this could definitely be a problem for many immigrants. If you've ever been in the country undocumented, if you've ever been in immigration court, if you've ever had a deportation order and maybe you didn't leave, definitely work with an immigration attorney that has experience that can really put a really good application together so that you don't have to go through a process of applying for a green card or what have you more than once. So I hope you found this video helpful. Please, please, please share this with any of your friends or family or anyone that you think would benefit from having this information. And if there's anything that I can do to help you with your immigration situation, please don't hesitate to call my office at 508-942-7497. You can also visit brazenlegal.com to learn more about me and my law firm. Thanks for watching, and please don't forget to subscribe.